You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today I'm talking about anti-money laundering, compliance, the Solicitors Regulation Authority, financial sanctions, any number of issues that law firms face on a day-to-day basis. And I'm delighted to say that I'm joined by Gavin Ball. Gavin is the Technical Director at HiveRisk, and it's great to have you on the podcast, Gavin, to share your insight and expertise.
Hi, David. Great to be here. Thanks for having me.
First question's always the same, and I know you've got some in-house experience as well. We were just chatting before we started the recording about some of your experience in a compliance roles, but tell us about yourself and also about your role at HiveRisk, please.
So my name's Gavin Ball. I'm Technical Director at HiveRisk. I have over 20 years experience in compliance and anti-financial crime roles, predominantly with large accountancy firms, with large law firms in various roles. For the last 7 years prior to joining HiveRisk, I worked as a head of compliance and a partner and MLRO for a mid-tier law firm, just breaking into the top 200, I think. In that role, I led a team of compliance analysts and compliance managers dealing with all things regulatory compliance and anti-money laundering for the firm. And then last year, I moved on from that firm to join Kate Burt at HiveRisk with a view to growing the business and turning HiveRisk really from what was then a small sort of boutique business into a much more well-known, well-recognised compliance provider in that market to law firms.
First part of the conversation then, and we'll dive right into the content here, is that the SRA has written to law firms informing them of mandatory information on money laundering and financial sanctions that they will be required to provide from the beginning of August. What is this information specifically as you understand it? And there'll be lots of questions that will come out of the back of that, no doubt.
Yeah, sure. So we've talked about this at some length now. HiveRisk did a webinar on this subject. Essentially, the SRA has written to everybody via its own webpage and via an external email, if you like, to all regulated businesses or regulated law firms, saying that they will require them to answer an online questionnaire around anti-money laundering and around financial sanctions. It will go live via their webpage, so it will be a portal via the SRA's webpage. And the questionnaire itself, there are already on the SRA's webpage a set of specimen questions, if you like. We don't expect those to change greatly from the specimen questions that are already there, but they're very much around things like, do you have anti-money laundering policies and procedures in place? Do you have risk assessments? Have you done training? And it talks about things like when were these documents last reviewed and updated, and it gives a range of answers that you can choose from. So you don't have to give specific answers. You can the answers are in ranges from 0 to 6 months, 6 months to 12 months, etc. So it's quite easy then just to pick the relevant answer to those questions. It also looks at things like what percentage of your work that you do as a business is within the scope of the AML regulations, what percentage of your staff work on work that's within the regulations, what percentage of your open matters fall within the AML regulations. And again, it gives you a range of answers then that you can give 0 to 25%, 25 to 50%. So they're quite broad ranges and quite easy to pick your answers from. But they are things that you'll need to have some knowledge behind, have some management information to hand to be able to give those answers and make sure that they're accurate. In addition, it also looks at things like anti-money laundering reporting. So how many reports have you made to the NCA, if any at all? what subjects were they on? Was it to do with property? Was it to do with trust and company service provision? So all of these different types of areas that you can be reporting on. And then last but not least, the area that applies to everybody, even if you're outside of the anti-money laundering regulations, is the sanctions piece. So they're very interested in, have you worked with designated individuals? How do you identify designated entities? What kind of checks do you run? All of these type of questions are in the questionnaire there.
Anti-money laundering seems to continue to be a real bone of contention for firms. There are obviously some that manage it very well. There are still plenty out there that are simply non-compliant, or at the very least elements of what they do are non-compliant, and it prompted the SRA to release their warning notice last year, and indeed this year alone. I'm reading up on today's conveyancer that we've seen fines of nearly £200,000 levied to law firms for anti-money laundering failures. What is it that firms are failing on, Gavin?
I think there are a number of key areas that we see as a compliance provider when we go in and do audits on law firms, and they match the areas that the SRA has seen. I think a lack of risk assessment is probably one key area that firms don't get right. Not so much firm-wide risk assessment. I think firms have become much more astute at those, much more aware that that's a big key area for the SRA. So firms are getting better at doing their firm-wide risk assessments. Where they seem to still be falling down is on client and matter risk assessments. So when you onboard a new client, when you open a new matter for a client, there has to be another risk assessment done. And still firms are missing that, or they're not doing it well enough. I think the other area that we see often followed up on, and we see it reported on quite regularly, is source of funds. Law firms still struggle with the question that we get asked more than any other question, I think, is how much is enough. They struggle with how deeply they have to make those inquiries into the source of funds. Is it just obtaining a bank statement? Do I have to go away and get pay slips? Do I have to go away and get inheritance documents if it's from an inheritance? And that probably is the most common question that we get: how much is enough on source of funds? And that's where law firms we see certainly are still struggling, and the SRA clearly is seeing that as well. That's where they're levying their fines.
There is a proliferation of technology that is supporting both of those issues, in particular onboarding and source of funds. What is a compliance business's stance on how firms use that technology? Because presumably it should be being used.
As simple as use it. I think, as you say, there are so many different systems out there now. Yes, there's a cost to using it, but some of those systems aren't that hugely expensive at all. And for, when you weigh that off against the potential of getting this wrong and the fine that you may get from the regulator, it's a no-brainer for us. Use a system. It will run all of your checks in one place. It will check politically exposed persons. It will check sanctions. You can tag onto it or bolt onto it a module now that will do your source of funds inquiries for you through open banking. So there are so many systems out there that you can use that will give you the answers all in one place. And simply, if you're challenged on this by the regulator, you can produce those reports and say, here's the checks that we've done. It doesn't need you to employ, as a law firm, to employ a person sat there doing those checks. Somebody can enter those details. It can be done by an administration staff or by one of your fee earners, whoever it might be, working on the matter in a matter of seconds to submit those details. And it will check all of the documents. It will check all these PEPs and sanctions checks, and ultimately give you a report that you can rely on, that you can use if you're ever challenged by the regulator.
But to come back to the point that you've made about understanding how much is enough, the technology is surfacing this information. What do firms need to do to use it and demonstrate their compliance?
One of the things that the SRA are very keen on, if you do use an electronic ID verification system, is do you understand the reports that you get back? Do you understand the information that it's giving you? And they will actually challenge you on that. They'll ask you to talk them through a report if they come out and carry out an audit. And I've been there myself as a former MLRO. I've been sat across the table from the assessor, being asked or being challenged to tell the assessor what the report is telling me and what do I understand of it. So certainly, whilst the technology is great, and it provides the information, you do still need a human pair of eyes on those reports as well, looking at them, looking for the issues, and that may well be a compliance analyst. It may be somebody more experienced as a head of compliance or an MLRO, but certainly it needs a human element involved in the chain as well. So that investment in compliance, I think, is still a key piece. Again, we understand and appreciate smaller high street firms don't have the resource to employ their own compliance teams or compliance people. But again, that's why our business, if you like, HiveRisk is thriving in this environment, because we can provide something that's bespoke or tailored to the size of the firm as well. So you haven't got to spend hundreds of thousands on a compliance team. It may just be enough to have somebody there that can help you out with those complex inquiries.
You've mentioned sanctions, and I know that politically exposed persons is a similarly challenging issue for firms. How do they navigate these waters? I mean, we get as a publication notifications about changes to the sanctions regime and changes to the sanctions lists. The Russian invasion of Ukraine and what's happening in Eastern Europe has had a significant impact on this. How do firms stay the right side of this challenge?
Again, very difficult one. Sanctions is ever changing, as you say. Very similar to the AML rules and regulations. There is a lot of change in that environment. There certainly has been in the last 5 or 6 years. It feels like the goalposts have been moved that regularly, and it becomes really difficult to stay on top of it. But again, I think using the systems is one of the key things. Use the technology where you can. It will run the sanctions checks for you. Will give you the information. It's quite rare to come across truly sort of designated individuals or entities from a sanctions perspective, but the systems will look for them, and the good systems will give you the info on designated individuals and entities very, very quickly, and you can then, using that human sort of element, if you like, cast a set of eyes over it and make a decision as to what you want to do next. Ultimately, most of our clients that we work with have a rule that just basically says anybody that's sanctioned, that's designated, we won't work with. It's the easiest way to go. Some firms don't. Some of the bigger city firms obviously work with sanctioned entities and individuals, and there's lots of work to do there in terms of obtaining licenses from OFSI and from the regulator to make sure that you can do that work. But again, lots of hoops to jump through, lots of hurdles to get over before you can carry out work with a designated entity or individual. So again, it's about having the right policies and procedures in place, having that human element that can look at those reports and make a decision on what you do next. Ultimately, escalation is key. Use the right people at the top of the chain to look at your reports and make those decisions. You shouldn't really have, and we do see this occasionally, a junior analyst being the person that's having to make a decision about whether you work with a designated individual or not. That should be right at the top of the chain. Decisions being made by equity partners and COLPs and MLROs and those type of people.
And my understanding of politically exposed persons is similar. It's a difficult line to tread, although it doesn't preclude you from working with them, which was a misnomer a little while ago, wasn't it? I think we've busted that myth now, but we can still work with PEPs.
Absolutely, yeah, and again, it's something that we've seen very occasionally is law firms sort of saying, "Oh well, we won't work with politically exposed persons," and we advise against that. It's a really risky position to take. You're potentially discriminating against somebody because of their role, or maybe it's not even them. It's a close relationship or a close relation that's politically exposed. So again, it's about having the policies in place, the processes in place, the escalation procedures. Have somebody with a suitable knowledge and seniority looking at those things and approving whether you're going to take them on as a client. It may be that you look at them and decide that their risk profile is too risky for you as a business, and that's entirely fine. But you shouldn't have a blanket approach that says, "Oh, we just don't work with politically exposed persons." You have to do it on a risk-based approach and look at what the risk is. They may be, based in a high-risk third country somewhere, countries like Iran or North Korea or something like that. And again, politically exposed persons in those regions, particularly risky people to work with. So depending on what the work is you're doing, It may be that doesn't fit your risk profile and you don't want to touch it, but having a blanket approach really isn't the correct starting point, I guess.
One of the criticisms that's levelled at the risk assessments that you've talked about is that they are templated. And it was a word that comes up in the warning note, and it's a word that comes up, or a phrase that comes up in a lot of the SRA communications. Can you explain to the listeners what the SRA means by a templated risk assessment and what firms need to be doing to avoid falling foul of that?
Yeah, so the SRA's template risk assessments they're very good documents, but they are just that, they're a starting point. So take the document, have a look at it, have a look if in its template guise it applies to your firm. If it doesn't, amend it. It's an amendable document. It's, you can take stuff out, add stuff in, add sections in. But I think ultimately the key bit is making sure that you have enough detail in there for the type of business that you are. So I've literally just looked at one of the templates, SRA risk assessments for a very small high street firm that just does conveyancing, doesn't do any other areas of work at all. And we helped them with making that template fit for their business and dependent on, as the SRA is often referring to, the size and nature of the business, which is one thing that's very key about talking about in your firm-wide risk assessment, the size and nature of your business and how and why you've amended and adapted that template risk assessment. So don't use it straight out of the box. The SRA generally don't like that, and make sure that you get plenty of information in there about what you do, what your risks are, how you mitigate them, and the things that you do on a day-to-day basis.
Give us some examples. What typically might that look like? I appreciate, it's going to depend on firm by firm, but what do firms need to be thinking about that's relevant to their situation?
So I think looking at things like clients, what clients do you work with? What locality are they in? So what geography are your clients in? And again, these are things that are all key headings in the template risk assessment anyway, but picking those key headings up and thinking about it more for your own particular business. So again, example, the very small high street firm that I've just been working with, their client base is all local. It's local people, probably within 15 miles maybe of the practice, that are buying or selling property. Again, buying or selling property is a high risk area, so you're constantly thinking about what are the risks here of the work that I do, the clients I take on, where are they based, where do their funds come from, and again, depending on who you're working with, the flip side of that is we've just done some work with a top 10 law firm and looking at their clients all based across all all over the world. They have offices all over the world. They have offices in South America, in APAC, and just immediately you're constantly thinking about the difference in risk there. How do they deal with onboarding their clients and what type of work do they do for them? So it's always about looking at those big headline sort of headings of client, work, locality or geography, building into that other things like funding, where does the money come from? Does it involve high risk countries? So all of those things again build back into how you form that template for your risk assessment.
It's a bit of a whistle-stop tour around the topic, so we're struggling to go into a huge amount of detail about everything. But one of the other questions I wanted to ask you is around suspicious activity reports. Again, you brought it up about when firms are submitting them. Again, what are they for as a reminder, please, Gavin? But then when should firms be thinking about submitting them? And beyond that, I think that there is some concern about tipping off as well, isn't there? Because you don't want to suddenly stop acting for somebody because it could tip them off that you think that they're on a sanctioned list, or their source of funds is illegitimate.
And it's an area that gets confused a lot actually around tipping off, which I'll pick up in a second. But tracking back to the original question around suspicious activity reports. So I think that the key thing here is suspicion is a very low bar, something that we say to everybody, and suspicious activity reports should be made where you have a suspicion that money laundering is involved in any matter that you're working on. Now, those reports should be made by your lawyers or by your fee earners or by your paralegals, whoever it might be that's working on those matters, to your money laundering reporting officer. and then it's your money laundering reporting officer's job to decide whether that then needs to be reported onwards to the National Crime Agency. There's ways and means of making those reports if you're an MLRO to the National Crime Agency, but ultimately most of the time now they're made through the NCA's online portal, reporting portal. The role as an MLRO is a very responsible one. It's something that we say a lot. We do a lot of training with money laundering reporting officers. It's not just a tick box role. It has a great deal of responsibility. It has a great deal of liability. If you get this wrong, if you fail to make a report or you don't make a report, you could be on the wrong end of a criminal offence and potentially, looking at whatever sanctions that carries. So making a report is a key area to think about, and think about who does that for you, who does that MLRO role. It has to be somebody with significant seniority, significant authority within the business, significant experience from an anti-money laundering perspective to be able to make those reports. But you should have some formal process for your lawyers, for your solicitors who don't understand the anti-money laundering reporting rules as well as your MLRO does, but a function that allows them to an easy function that allows them to make a report to your nominated officer when they need to do so. It's generally done in a template form that most of our clients use, and we pass to our clients to use, because then that kind of guides what they need to put in there in terms of a detail that's going to your MLRO. As I said before, the role of the MLRO is much more difficult. There are different things to consider before you make a report onwards to the National Crime Agency. Having been there myself as an MLRO for 5 or 6 years, I know that there were things that often came across my desk that I had to put some real time into considering whether they were reported onwards. Is there enough of a suspicion there? What does it involve? Where are the funds coming from? Who's the client? Does legal privilege apply? If legal privilege applies, actually there's a reporting exemption. As an MLRO, you don't have to make a report to the NCA. That doesn't mean that your solicitors don't have to make a report to you as the MLRO, and that's something else we see people get confused about quite often. Litigators are often the ones who will say to me, "Oh, I don't need to report this to my MLRO because legal privilege applies," but that doesn't apply to the lawyers. That applies just to the decision made by the MLRO, whether they need to report externally, whether they need to make a disclosure to the NCA. So that's an area that's very complex, legal privilege, and often you should be seeking counsel's advice about whether to make a report or not on those type of things. The tipping off point that you make is another great one. So we often see lawyers get confused that whether they can ask further questions that help them with things like understanding the source of funds, or understanding onboarding their client and understanding their client's identity, what country they might be coming from, things like that. And they get concerned about tipping off, and you can't actually make or commit a tipping off offence unless you've made a report already, an AML report, because it's all about prejudicing an investigation. So if you haven't made a report, there isn't an investigation for you to prejudice. So getting that distinct difference between asking further questions so that you can onboard your client and asking further due diligence questions so that you understand the source of your client's funding doesn't put you in danger of tipping off a client. It's only at the point where an AML report has been made, either to your MLRO or onwards by your MLRO to the NCA, that you're then in danger of a tipping off offence. So you then can't go back and tell your client, "Oh, well, this matter's delayed for a week now while we wait for the NCA to come back and tell us whether you're a money launderer or not." There was a case quite recently where a solicitor was prosecuted for deliberately tipping off his client that he was under investigation by the Serious Fraud Office, and I think from memory he received he was struck off, received a 2-year suspended sentence as well by the courts for that. That's the only tipping off offence I've ever seen prosecuted, actually, and it wasn't a very sort of egregious one. The solicitor went out of his way to go to his client's house and tell him about it, so it was a very sort of obvious offence, but it is nevertheless still something that people should be thinking about if they've made a report to their nominated officer.
Do you stop working on the case and for the client, or do you continue? Because if you stop working, that could be an example of tipping off. And forgive me, I remember very vaguely in the Grey matter something about a defence against money laundering, a DAML.
Yep, that's right. Yep. So if you've made a report to your MLRO, you should always seek advice from your MLRO about next steps. Most MLROs I know that are considering then making an onwards report to the NCA will tell the fee earner to stop work. And the reason for that is that that generally from the point of making a report, you should have something that you just mentioned there, a defence against money laundering or a decision, let's say, from the NCA within 7 days. So it's not a long time not to work on your client's matter. Hopefully you're making all the enquiries early doors, which is something else we talk to our clients about a lot, about managing your clients' expectations, telling them very early on about the anti-money laundering rules and regulations and the inquiries you'll be making, just as a standard onboarding, a part of your onboarding. But then, of course, if you've done that early enough and you do come across a problem, it doesn't create an issue then if you have to wait for 7 days because you've made a report. Whereas if you leave it right until day before completion, everybody's having a mad panic and you have to stop work and the completion can't go through. And that's a horrible position to be in. So it's always very much about making those inquiries as early as you can. So when you make a report to the NCA, generally what you're doing is you're asking for a defence against money laundering. So you're saying to the NCA, have a suspicion here. This is the money involved. This is why I'm suspicious. This is why I think money laundering may be involved in this matter. And what I'm asking the NCA for is permission to go on and complete this transaction, whatever that might be. Generally, it's property matters. So you're asking to complete on the purchase of a property using funds that potentially are the proceeds of crime. Most of the time, and there's reasons behind this, the NCA will come back and give a defence against money laundering. Not all the time. I've been on the wrong end of a few refusals as well, which then makes life much more difficult and you have to think about what to do next. But most of the time you will get a defence, and often the reason for that doesn't mean that the NCA don't suspect that the funds involved are the proceeds of crime, but there may be a bigger picture behind the us as an MLRO or as a fee earner don't know about. There may be a bigger picture that the NCA is building so that it can pursue a prosecution further down the line. So sometimes they may even give defences against money laundering even where they suspect money laundering is involved. But if you have that defence, if that comes back through, you have to receive it within 7 days from the NCA. You'll generally get it on day 7. You won't get it any earlier than that. And then you then have that defence that you need to go on and complete your transaction and do what you want to do. If you do get a refusal, obviously that's a different story. You then have to think about, well, A, I can't tell my client about this, so I can't tip them off. B, I'm now stuck with this. How do I either offload it or what do I have to do to move it on? So sometimes then what you then enter if you get a refusal from the NCA is something called a moratorium period, which is 31 days long. So you may then be waiting for 31 days for the NCA to tell you what you can do next and whether you've got that approval. And actually at 31 days, they can apply for a court order for a further 31 days. So you can be stuck with this position actually for a matter of months, which is a really, really difficult position to be in, particularly as an MLRO, because your client is then going to be knocking on the door saying, what's happening? Why isn't this moving forwards? And you can't tell them. You can't give them. It's a really difficult position to be in because, again, under the principles for a solicitor, if you like, the SRA principles, one of the things, or two of the things there are around honesty and integrity. So how do you tell a client that you can't move their matter on because it's related to money laundering, which you can't do without actually lying to them? It's a really difficult position. I have been there. It's a very difficult position to be in. Often you have to just make very sort of general comments around things like there's a problem with the bank or there's a problem with the money, which isn't a lie, but you obviously you're not elaborating that it's a money laundering concern.
That's a really comprehensive review of what firms need to be thinking about. So thank you for that, Gavin. You mentioned that you've run a recent webinar about anti-money laundering and the requirements that are coming down the track from the SRA. There was quite a lively Q&A from memory on the session. What were the key kind of themes and questions that came out of that's worth sharing with listeners?
I think a lot of the themes that we saw were from compliance people who work in house and law firms around things like, if my firm isn't in scope of the AML regulations, will I still receive one of these questionnaires? The answer to that is yes, because the sanctions element applies to everybody. So you still have to fill in section 4, which is the sanctions section. Then there were questions around who will be in scope within our teams, so and what type of work will be in scope. So again, anything that you deem as being in scope of the anti-money laundering regulations is the stuff that you need to be looking at in terms of pulling your facts and figures together for the questionnaire and for your answers. Then there were questions around the logistics of answering the questionnaire. So how is that going to happen? My understanding is that that's going to happen through the portal, which will go live on the SRA's website or web page, the same web page that they currently have available, where they talk about the questionnaire and they provide the sample questions. There's going to be a portal on there. You log into it using your own MySRA login details. It has to be completed by one of your nominated officers, so your MLRO, MLCO, or your CULP. One of the things that we've been very sort of vocal on is the accuracy of your answers, making sure that any answers you give, you're confident on the accuracy of. And the reason we say that is that what often happens with these questionnaires is they're followed up on at a later date by the SRA. So the purpose of this questionnaire is to help the SRA target their audits at the correct audience. So the higher risk firms, likely the ones that come out as higher risk from this questionnaire, will be the ones that likely have an audit, an on-site audit or a desktop-based audit. So very much, giving the right answers is key to that, whether you then have a follow-up audit or not potentially. And if the answers you've given aren't accurate or based on the evidence that you then have to provide to the SRA during an audit, they may well come back and ask you why those answers weren't accurate. And we've seen that in particular before they did a similar thing with a declaration that was sent out a little while back about price transparency on law firms' websites. So people filled in that declaration. They then got followed up with an audit of the website by the SRA, and the SRA actually found that where they'd made the declaration that the firm was fully compliant, the SRA then came back and said, well, actually, we've looked at your website and it isn't fully compliant. Why did you tell us it was 2 years ago? So the same sort of thing applies here. Make sure that your answers are accurate, and that was one of the things that came out of the discussions we were having on the webinar. And then just other bits around what do you do if you have very small percentages, less than 1%. And I think this is on the SRA's FAQs on their website as well. It's just a rounding up exercise. So if it's less than 1%, round it up to 1%. So it brings you into the range of answers. And of course, there's questions in there as well that won't apply to everybody. So there's a whole set of questions around trust and company service provision. Many law firms don't undertake it or don't do it. If it doesn't apply to you, obviously you don't need to answer that section. So those were the kind of themes we were seeing on the webinar as well when we did our webinar the other day.
We started at the top of the conversation by saying that anti-money laundering continues to be a massive, massive issue for firms. And we were talking before we started the recording that even the role of the CULP and the COFA and the money laundering reporting officer and some of the other compliance roles still feels foisted on people, doesn't it? That perhaps it's an equity partner or perhaps it's certainly somebody with still some fee earning responsibility. Whereas I appreciate you run a compliance consultancy, so you may very well have a biased view on this, but it does feel as though firms are under more and more pressure to dedicate more time and focus to this.
Yeah, absolutely. And the genuine answer is that they are. That's not an answer as somebody that runs a compliance consultancy. It's becoming a role that has to be dedicated. We still see so many fee earning partners that have these roles and they just don't have the hours in the day to do it, and you can't apply the time that's needed to doing the role properly, and then consequently what happens is they get into sort of an arrears situation where they aren't doing the compliance work. The fee earning work is nearly always going to come top of the priority list because that's what it is. It's earning the fees for the business. So the compliance work gets pushed down the list, and then you're not updating your policies when you need to, and then suddenly you find that your policy's 4 years out of date and you've got an audit coming from the SRA, and there's a mad panic to then update all of your policies and make sure that they're accurate and up to date. And that's the kind of thing that we see, my business sees as on a regular basis. We often get calls to come in and work with clients 1 week before the SRA are due in to audit them and help them try and put their policies right, because that's what's happened. In my role as a partner and head of compliance, I was a designated officer dealing with that work, so I didn't have any fee earning responsibilities. I just purely dealt with compliance for the firm and running the compliance team for the firm, so that allowed me to focus on it and make sure that we were up to date with our compliance work. But it's such a difficult role to have if you're fee earning at the same time as well.
And as you said, there are some serious liabilities that come with it, some criminal liabilities as well.
Certainly for the MLRO role, for the money laundering reporting officer role, if you're not doing that job correctly and you're not making reports when you should be, it is a criminal offence. There's an offence under the Proceeds of Crime Act that basically says, failure to report a money laundering issue is a criminal offence. I've not seen any MLRO facing prosecution on the basis of not reporting yet. I have seen one prosecuted for being deliberately involved in criminality, an MLRO that wasn't making reports because they knew they were working with an organised crime group, and that solicitor was given a custodial sentence. But I haven't seen anybody prosecuted for kind of an erroneous, if you like, or an error in reporting. Not yet.
No, well, yes. As you say, not yet, but the SRA, it's very obvious that they have got or are increasingly bearing their teeth on this, and firms should be minded to pay attention would be my recommendation. We're out of time, Gavin. It's been great to have you on the podcast and share your insight and your thoughts on the challenges that firms face. Thanks so much for joining the podcast.
Thanks, David. No, it's been great to be on the podcast today, and hopefully we've given a little bit of information to your listeners.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. My thanks to Gavin. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.